Yes.
May I please, the Lordship? My Lord, I beg to mention item number 20, my Lord. In this matter, we are filing the affidavit today, my Lord, for the Health Department.
Concern of the petitioner?
Yes, my Lord. He is there, my Lord.
Item 20 is the request.
He is there, my Lord. I have taken consent.
Respondent has been referred to be listed after 3 weeks, enabling him to file the affidavit in opposition. Mr. H.K. Da. H.R. Da. Petitioners are also permitted to file joint affidavit to advise them.
Obliged, my Lord.
May I please, Your Lordship? Item number 49, Lordship. I'm for the petitioner and she's for the respondent, Lordship. This matter may come after vacation, Lordship.
Item 49 is agreed to by both parties. After in the 4th week of July. The date to be fixed by the law.
Keep your black.
Yes.
May please, Lordship. Lordship, I beg to mention item number 24, Lordship, with the consent of my brother, Lordship. After 2 weeks, Lordship.
24.
I'm for the petition.
At the request made by Mr. A. Gogoi, understand the 4th week of July.
Lordship.
M. Sahibal.
Obliged, Lordship.
Yeah, please, Lordship. My Lord, I beg to mention for listing, my Lord. My Lord, we have already filed our yes.
Listing in court 5.
Obliged. So item number 28 to 33, Lordship.
Yes.
I need some accommodation, Lordship. I have taken consent, Lordship. I will give instruction for 10 days, Lordship.
Who's for the 28 to 33. The request made by Mr. Sharma has not objected by the council.
So I have another prayer request, Lordship. Item number 19, Lordship. We discussed what had happened earlier. Another council was appearing, Lordship. Actually, he is not now. If some
Lordship, item number 9, I am for the petitioner.
19.
19 or 9?
19.
9.
19, I am for the petitioner. Lordship, more than 1 year has elapsed. They have not filed a reply. And Lordship, there is an order on the last occasion that an endeavor will be made to dispose of the matter today due to urgency of in the matter.
Lordship, in that order, Lordship,
And there is an interim order also operating.
Lordship, in that case, Lordship, I have some.
an interim order in your favor.
But I do not want to take the benefit of interim order continuum because it is a matter of promotion. If the
So only
10 years junior has been placed above me.
only for 7 days accommodation, Lordship. I will take all the documents, Lordship. Earlier council has resigned,
You
Lordship.
need to reconstruct the brief.
Lordship.
Then 7 days time a fixed date may be given, Lordship.
19 at the request made by what briefly presented by an early by council. It's after 1.
Lordship, then can a date be fixed? Because earlier also it was fixed. It is a fixed matter.
Yeah, no issue.
16.
And you're blessed.
Obliged, Lordship. Interim order may be continued.
Interim order pass 30.
May I please, Your Lordship? I'm for item number 18.
Item
18.
18.
Yes.
18.
Yes. The dusty service has been completed and we need.
Mention you make it when the matter is called up.
May you please, Your Lordship? Lordship, I beg to mention item number 41 with the consent of the other side, Lordship. I'm from the respondent, Lordship, on behalf of Mr. S.
I am for the petitioner.
Yes. Any objection?
Let it be after a week.
After 1 week, we're not having it. It goes after vacation.
Then after the vacation.
Item 41, the request made by the council. First week of August.
Yes, Your Lordship.
That's
Much obliged.
Black.
I beg to mention item number 47.
47.
Lordship, we have to file a rejoinder affidavit. The matter is fixed for next week, Lordship.
Next week after vacation. 47 at the made by the council. Filing a rejoinder affidavit.
given again.
It is the respondent of the account. Yes, you got
So
it.
47 point.
Yes,
My item number 11, my lord. In the IA, my lord, we are supposed to file a affidavit. I will be getting the instruction today. Can it be next week? It's a transfer matter. I'll file my affidavit by Friday.
the joint request, the request of counsel, the health part. Has differed.
Perimeter is operating it.
The order path will be
Can be on Monday or Wednesday. my lord.
Mr. Adam Teka, I guess. So 18.
Obliged.
Please, Your Lordship, the consent of the RL site, Lordship, I beg to mention item number 48, Lordship. Matter may kindly be taken up after the vacation, Lord.
Item 48, that the request made by the counsel for petitioner be listed after the.
Madam, section 11 application. Madam. Section 11 application for appointment of arbitrator. Like notices go, madam.
If you notice, it crosses the represented by Mr. Rita. The way down the copy departed in a period of one. The respondents are at liberty to file their objections if any.
Grateful. Obliged.
Lordship, here we are yet to receive complete instruction in the matter, Lordship. A short date may be fixed, Lordship.
What short date?
Uh,
His claims not being furnished. Friday,
Lordship,
Friday,
Lordship.
but please ensure that the instructions are there.
Lordship, it may be fixed after, maybe on a Monday, Lordship.
Monday,
Lordship.
yeah. Where, wait, loud, like.
Highly obliged, sir.
Obliged.
My lord, in this case, I'm appearing for the university, my lord. On last occasion, my lord, I was directed to take instructions. My lord, I have received instructions yesterday. And I think, my lord, I need to file an affidavit.
Is it contrary to your submissions last?
No. Last my submission was to get the instructions. I have received the instructions. But it's too voluminous, my lord. So let me file an affidavit.
So your submission last was little more than that. All right. Let him file the,
My
appeal.
lord.
Then we'll keep it for, we issue notice that. The understanding
Yes.
was that if the university revisit the issue.
Yes.
Maybe in their favor.
Exactly. But what has happened, my lord?
Perhaps it is not entirely.
Yes,
their
my lord. That is why, my lord. That's why I thought, because their names were in serial number 1 and 2. From 3 onwards, promotions were made. So apparently on XPC, my lord, I was also of the opinion that perhaps petitioners may be denied. But my lord, it seems, my lord, they have a ground that they should not be promoted right now.
So we'll issue notice that.
Let notice
Right.
go.
But council to part. The PN was not. Council appears for. Ordinance
1, 2, 3, my lord.
one with. Whoever, who is for 4?
4 is the Association of University. Let notice go through registered post, my lord. Employees Association, my lord.
Mr. Swami represents the department, the way of the party. Steps on respondent 4 to 32. By registered post CD. And you could take it within 2 weeks. The departments are at liberty to file their. Immediately after the after the deadline.
My lord, till then, my lord, no promotion will be made.
Already promotions order have been issued, my lord.
You are challenging them.
Yes, my lord, there are other incumbents, my lord.
What
new
I'm saying,
incumbents also
the
there. my lord.
petitioner is found to be entitled, my
Any
lord.
promotion,
Get it
any
retrospective.
promotion made the meantime shall be subject to the
My
act
lord.
of.
My lord, I'm deeply obliged.
Please, your lordship. Lordship, I beg 2 weeks' time for filing of the substitution petition in respect of petitioner number 10.
Counsel for the petitioner prays for weeks time to file application. We'll give you 4 weeks time. File
Yes.
application for substitution of the legal heirs of
Petitioner number 10, lordship.
number 10.
10.
Is submitted by Recruitment. To be listed after 4 weeks.
Obliged.
I bear the proceedings.
Hello.
Yes, sir. Yes, anything?
Lordship, last instruction is of 2017. In which the petitioner was getting an enhanced pay, maintenance allowance of 3,000.
Last date, liberty was granted to enable him to enable your colleague to get updated instructions. Not available. Counsel for the Dharma is permitted further 4 weeks time. Complete her the man. To receive updated it's taken after 4. Yes. Appeared to purely for the end of justice. But
Next, please, your lordship. My lord, in this case, lordship, we had already taken the steps, lordship, but the acceptance of this lordship, I could not propose this lordship inadvertently, lordship. But we have
counsel for the petitioner. With that steps have already been taken.
the official respondent, lordship, comment, lordship. I already served the copies to them, lordship. But
Acceptance notice has to be received by the section.
lordship, I'll inadvertently, lordship, I'll submit
Counsel
it
for the prays for 2 weeks time.
by
Complete step
today itself, lordship. Now I'll propose it.
by submitting the acceptance. The acceptance for the before the registry.
They have paid all the dues excepting the leave engagement. So they are supposed to take instruction as per your lordship.
And areas help.
Yes.
Lordship, we have tried our level best to pay the leave encashment, but due to non-availability of the in the portal that we have stated, Lordship.
What portal is it? Report.
What is it now?
Lordship, this is the letter which I have received.
They say that no area salary is there, but leave
Leave
encashment is because it can't be done because you are not a regular, you are not entered into a regular case.
Regularization, if T17 or nothing, then
What they say.
yeah, this is one. They have difficulties with, I think,
So with the finance
digital.
department portal,
digital thing. They will have to rectify themselves.
that we cannot rectify until and unless the direction is given to the finance department from the zonal. Because finance department has to open that one.
Finance is not a party here.
Lot. Finance is. Finance, there, Lordship.
Finance is there.
Lordship.
Then where is the council for
Right,
finance?
corner number 7. Lordship.
Finance council. Pro-
Seven.
Because if your lordship turns one page after the main page, then your lordship will find that we have raised the query in the FINASAM portal and they have answered the query our as raised from our end.
You have raised the query that what
Whoever
you have
controls
raised
the
the query. There's not, no reply has been received back.
No, reply they have given lordship, if left side, closed remarks. Dear sir, stroke madam, left hand side lordship of that same page. Query we have raised on the right hand side and on the left hand side they have
We have 2 pages.
on the first page lordship. That's all.
First page.
Right hand side, we have raised a query with a request, that is the request details.
I don't know what you have given me.
Lordship.
Is 2 sheets of letter. Yes, Mr. Tolia. You show him the instruction here. It appears that the leave encashment available to the petitioner
Lordship.
is not released because your portal does not accept the paper.
Yes, Lordship.
So you need to get your instruction
Lordship,
from the. Your commissioner is a respondent here.
Yes, Lordship. Yes, we'll be like-
But Mr. P.T. Thakur,
We have photo, photo. And
board.
the Mahasa Uttamman.
Final. Board, 1 to 7. You are representing 1 to 6.
Lordship.
RM Thakur is one. Yeah. One to 6.
No, Lordship, 4, 5 and 6. 4, 5 and 6.
4, 5 and 6.
Yes.
I prefer respond on 129.
Mr. RM Thakur responded 4, 5, 6 and 8 also, I think. No.
No.
4, 5, 6. Mr. RR Gogoi for 1.3.
120.
Mr. Etulia 7. And you, sir. 8. Not for accounting. In terms of the earlier order, the Mr. Das was the RM Das. The council representing the 4, 5 and 6 was opportunity complete by Arrears and even. It will be good. There. There are- If that even get left be each state, however, areas are the sorry, there is no areas are the however, even as far as the not process as the finance department portal does not accept entries with regard what judge were not brought into regular pay. The query put up by the item 6 item 3, so it closed without resolving the third circumstance. We permit Mr. Include 7 did instruct that it to be listed again after 4 weeks.
Date,
First of August,
first of August.
Yes, so my lord, here, the respondent, they have filed with appeal. They have filed with appeal in this case,
they have filed an appeal.
my lord.
Who has filed an appeal?
Contempt, my lord, respondent,
They have filed an appeal.
my lord,
Matter is pending.
Yes, ma'am.
pending.
It is submitted at the bar that the respondents have preferred appeal against the judgment and order dated
And then order.
12/9/2023. Passed with the PPC number 45. of- Appeal has been registered.
Yes,
and
madam.
Yes, my lord.
WA number 95 of 24.
The appeal is numbered as
95, WA 95 of 24.
95 of 2024. That view of the matter, the contempt that paper to be listed after 6 weeks. 8 weeks.
In the meantime, I may be allowed to take fresh steps upon the new incumbent.
You wait, let us see what is the state of the appeal after 8 weeks.
Right.
May it please your lordship. Lordship, in this matter, I may be granted 1 week time to file an II, lordship. An implement II.
So the petitioner prayed for 2 weeks time to file the IA for implement of fresh report. Where may be allowed it.
Achha. My lord, matter is already complied with.
My lord, direction has been supplied.
It's submitted to the bar, the direct date in the order dated also part in the PP. So it's also complied with. Petitioner is not. Petitioner does not wish to press that view.
Obliged.
I plead the lordship.
Yes.
My lord, IA number 1626 of 2025, my lord. This has been filed paying for vacation of an ex parte order passed against the petitioner, my lord. Which is at page 71, my lord. Page 71, my lord.
My lord, I would like to file an objection against this IA, my lord. It's come up for the first time.
Second time.
Yes, my lord, the first time.
It
there
has been
was-
filed long back, 21/3/2025, my lord. And due to this stay order, interim order, my lord, the petitioner is not promoted to his next promotion and post, my lord. His promotion has been held up, my lord. Otherwise, my lord, his juniors have already been promoted, my lord, to the next higher post of APS grade 1.
You file your objection.
My lord, my lord may give me at least 2 weeks time to file an objection, my lord, because the private petitioners here are 40 in number. So, and the signatory authority is placed, I need at least 2 weeks time, my lord, after.
The DP Bora. HP. Sharma.
My lord.
He is for the respondent. Mr. Sharma. That. That's what. Right? What is the order passed here?
My lord, the order is passed.
Not to take coercive action.
Yes.
Yes, my lord.
Not to take coercive action superseding the petitioner, my lord.
You are on the behalf of the private respondent.
Yes, my lord.
I am on the behalf of the private.
I'm the original
You are the
petitioner.
petitioner. DP Bora for applicants respondent. And Mr. Deputy Sharma for petitioner. What coercive action of superseding?
The petitioner.
Because in the gradation list, petitioner is above the private respondent, applicant is above the petitioner, my lord. In the gradation list of inspector, my lord.
Mr. Sharma. It's taken after weeks.
My lord, kindly a date may be fixed, my lord. Because they will getting petition.
Can you file the objection?
A date may be fixed. Any date, my lord, subject to convenience of your lordship. Oblige, my lord.
20 June, my lord.
June.
20th June. My lord, the interim may be continued till then, my lord.
Interim order to continue until further.
Much obliged.
Deeply obliged, my lord.
Item 13. May it please lodge. So in terms of the order dated 9/12/2024, we have filed this interlocutory application for implement of Director of Ayush Assam as respondent number 5.
Any objection?
Lordship.
Heard, Mr. D. Public. You're also
I'm sorry.
Council. A has been filed for the appointment of Director Ayush. One full number is good. As respondent number 5, the company. I don't think so. It is submitted that. What is your prayer in the writ petition?
There, my lord, is regarding consideration of pay revision in family pension.
The prayer in the writ petition is for consider pay review applicant received by the inspector of service by her husband, petitioner's husband was working under
My lord, he was medical officer.
working was serving as a medical officer. The bracket Ayur.
Ayush.
Ayur or Ayush?
But,
Ayush.
Ayush.
No, it is Ayur. Medical officer Ayur. He was Ayurveda.
Ayur.
He was Ayurveda.
Lord, I'm not sure, my lord. Difficult.
Or the petitioner.
Yeah.
Ayush.
It's Ayur, my lord. Ayur. At page 13, annexure 1.
In your writ petition, you have written Ayush,
I'm sorry, my lord.
legal officer, Ayush.
I'm citing error.
That view of the matter. In order to indicate the claim of writ petition, the opposite party, namely director of Ayush, Assam, is in sleep. The respondent that can state do not object to the prayer made. Since this is an application in complete matter, fresh respondent, this court is of the and they close at its state without notice, else the newly implemented respondent will have ample opportunity to respond to the claim by finding it in the accompanying right out. Director Ayush Kam, what six graded respondent type in the of 24 of 25 amended for title Department. I according to stand post allowed the writ petition to type in view of the order passed in the IA. View of the order passed today in IA. Director I of Ayush, the rate is important number 5. Petitioner will file amended title. A registry from who will appear on behalf of Ayush?
I am under health
That's H. Sharma, the accountant hearing of health department, being present in court. To submit that he can represent newly elected respondent number 5 or state notice written at court. It's not any of health. The with the wave on the regular copy, the department. A newly implemented respondent, another respondent may complete their field by signing the sentence.
I'm okay.
If your PWD was to file an affidavit, if we sent it for vetting, we kindly grant us 2 weeks time.
No, next week. Let's close this matter. This is for what?
Pension lordship.
Pension.
Lordship.
What charge?
Officer lordship is but his name was
already
approved.
heard one matter it is.
No, yes, lordship. No, that this matter was different. That is why it was segregated.
So how different is it?
Here, lordship, the petitioner's service was approved by the approved for regularization by the finance department, lordship. This is the and the petitioner appointed prior to 1493, lordship. That is why, lordship, it was seconded.
That the affidavit would not be filed.
That may be different.
Or if they file an affidavit, you file a rejoinder, perhaps.
Lordship, immediately, lordship. Not required, lordship. Actually, my
But
service.
after 2 weeks.
Obliged, lordship.
Please, your lordship. My lord, I think nothing remains in this case because my lord,
The M. Soikel and the petition has become infractuous. Against according to the as a truth, interim orders, if any, stand vacated pending higher dismissed.
It is.
Yes.
Their part, my lord, they have not
filed any affidavit there or responded.
Lordship, the matter, the department has taken up the matter with the learned Advocate General, Lordship. Short, some time may be given, Lordship, for us to obtain instruction in the matter.
So the time is great. You're fine.
No, Lord,
Affidavit, fine.
not filed, Lord.
Let me fix a date. All right.
Please, Lordship, here this matter is regarding retirement benefits and regularization of the services of the Lordship. Here, we were directed to file an affidavit on the last date, Lordship. Here, the issue is, Lordship, he has been employed by the PWD. And Lordship, we have written a letter to the PWD authorities also asking for a status, to furnish a status, because they are the bookkeeper of the petitioner. Lordship, here,
Department not to have filed their affidavit, my lord. They have earlier
Lordship, I'm
also
taking
taken
some
time.
time so that we can pick up the matter with the authorities in the PWD and file our respective affidavit.
PWD file.
No, my lord.
That is the
Lordship will file
sometime maybe
sometime.
immediately after the vacation, Lordship.
You are representing PWD file.
I am appearing for finance. Lord.
File.
Yes, sir. We have already communicated down.
How much time do you require?
Lordship, immediately after the vacation, in the meantime, we'll coordinate with the authorities in the PWD and
Okay, important. Right.
like
Lordship. On the last date, we are permitted to take steps through Dusty service, and the services completed year started. And please allow us to file an affidavit
Your port,
petition.
H.C. Sharma. Only sole response.
port. What do you have?
Actually, on the basis of which agreement they have sought to appoint arbitrator, that agreement is already instructed, Your Lordship. I'm part one,
Are you filing any?
not till this day.
Not filing.
Maybe allowed time,
What we allow you don't want to allow.
or 3 weeks time maybe. Okay.
Okay.
my lord, on 6th, my lord, the hearing has taken place, my lord.
Yes, yes.
Hearing has happened, Lordship, on 6th of this month, my lord.
What happened?
My lord, I think, my lord, the case is fixed for
Who's
judgment, my lord.
Department? Revenue. What happened? Hearing?
Revenue, hearing.
You don't know, petitioner, you don't know what happened.
Lordship, submission for written agreement is fixed on 13th.
Huh?
And submission for written agreement is fixed on 13th. And most probably orders will be passed on 16th.
Still pending.
Submitted with the matter is still being heard by the authority. After it's recording.
Yeah, पहले इसको सब करते हैं
Oh.
Yes. Yeah. For me.
What?
I'm praying for 3 weeks time to file FTP.
Section. For appointment of applicant.
Yes.
Yes, ma'am.
Like,
The respondents have not filed their affidavit, Your Lordship. It is with respect to non-renewal of my notary certificate, Your Lordship.
Hey.
That pays 30, Your Lordship. May I repeat? In exercise of the powers conferred under Section 3 and Section 10 of Notary Act 1952, the Governor of Assam is pleased to reject the renewal of practice of notary certificate of the Sandeep Thakur, Notary Public of Tinsukia District, Assam.
Why
Saying
is it
no reasons were provided to me, Your Lordship.
sir? Sir,
Well,
why you take it?
not a rejection actually. It is not, renewal was not done.
You order the rejection. Did you get? Check. Any reason, any particular material why?
So one, my learned friend has obtained one instruction, but there,
You not only reject your feet to
well, maybe they have learned this properly. Well, possibly we'll have to take further instruction because one instruction in writing has come, but it's quite vague and it's basically relying on the discretion they have. But the discretion also has to be based on some materials. Possibly some more deeper instruction will be necessary.
he's the lawyer.
Yes, Your Lordship.
Yes, right. But is like
Exactly. Lordship kindly takes up the Notaries Act for a moment. Notary- Section 3, Your Lordship.
Section 3.
Section 3, power to appoint notaries. Power to appoint notaries. The central government for the whole or any part of India and any state government for the whole or any part of state may appoint as notaries any legal practitioners or other persons who possess such qualifications as may be prescribed. Then Section 4 says registers. The central government and every state government shall maintain in such form as may be prescribed a register of the notaries appointed by the government and entitled to practice as such under this Act. Then Section 5, Your Lordship, entry of names in the register and issue of renewal of certificates of practice. Every notary who intends to practice as such may, on payment to the government appointing him of the prescribed fee, if any, be entitled to have his name entered in the register maintained by the government under Section 4, and to the certificate authorizing him to practice for a period of 5 years from the date on which the certificate is issued to him. The government appointing the notary may, on receipt of the application of the prescribed fee, renew the certificate of practice of any notary for a period of 5 years at a time. Now, Your Lordship, Section 9. There is a bar to practice without certificate. Subject to the provisions of this section, no person shall practice as a notary or do any notarial act under the official seal of a notary unless he holds a certificate of practice in force issued to him under Section 5. Provided that nothing in this subsection shall apply to the presentation of any promissory note, hundi, or bill of exchange for acceptance or payment by the clerk of a notary acting on behalf of the such notary. Nothing contained in subsection 1 shall, until the expiry of 2 years from the commencement of this act, apply to any such person as is referred to in the proviso to clause D of Section 2. Provided that in relation to the state of the law, this is not required. Then Section 10, removal of names from register. The government appointing any notary may, by order, remove from the register maintained by it under Section 4 the name of the notary if he makes a request to that effect, has not paid any prescribed fee required to be paid by him, is an undischarged insolvent, has been found upon inquiry in the prescribed manner to be guilty of such professional or other misconduct as in the opinion of the government renders him unfit to practice as a notary, is convicted by any court for any offence involved moral turpitude, or does not get his certificate of practice renewed. Now, these are specific especially provided in this Act, Your Lordship, as to how it can be removed. Then, Your Lordship may kindly peruse the rules, notary rules. Appointment of a notary. Rule 8, Your Lordship. I'm coming to Section 4, sub-rule 4, Your Lordship. 8.4. Where this application is allowed, the appropriate government shall appoint the applicant as a notary and direct his name to be entered in the register of notaries maintained by that government under Section 4 of the Act, and issue to him a certificate on payment of prescribed fee authorizing him to practice in the area to which the application relates, or in such part thereof as the appropriate government may specify in the certificate, as a notary for a period of 5 years to the date on which the certificate is issued to him. Then, Your Lordship may kindly peruse Section 8B, Rule 8B, renewal of certificate of practice. The certificate of practice issued under sub-rule 4 of Rule 8 may be renewed for a further period of 5 years on payment of prescribed fee. An application for renewal of certificate of practice shall be submitted online in form number 14 to the appropriate government before 6 months from the date of expiry of its period of validity, provided that the appropriate government may, after considering the reasons stated in the application, relax the condition of submission of application for renewal of certificate of practice before the said period of 6 months. provided further that where an application for renewal of certificate of practice received within 1 year from the date of expiry of its period of validity, the appropriate government may, after considering the reasons stated in the application, renew the certificate of practice with effect from the date of expiry of its period of validity. So, Your Lordship, in this case, the certificate of practice issued under sub-rule 4 of Rule 8 may be renewed for a further period of 5 years. So they have not done that, and there has to be a reason, Your Lordship. In my respectful submission, no reasons were provided to me.
Can be specified because once the instructions come in this manner, can we observe that what is the reason for not making that maybe? But like the fixed statement that on the next it can be disposed. July.
Very grateful. Your Lordship.
Lordship, in 16, affidavit is ready for swearing, Lordship. Kindly allow me a week time, Lord. Lordship.
Keep the copy of affidavit. One file, joint file.
Deeply obliged. In 27, Lordship, instruction has been received, Lord.
The SP that
Yes, Lord.
file your affidavit.
Yes, Lord.
For social justice, your lordship.
Interim, there's an interim order, madam. Madam, there's an interim order.
Continue.
Lordship, I have not received a copy of
I
the
will give it-
petition. All right.
Within
They-
My lord. My lord, I'll give it to you.
Please, your lordship. Actually, my senior is in late. Kindly pass over the matter for time.
Lordship, in this case, it's about the selection of Havaldar clerk in the Assam referee. And this case, your lordship, in the typing test, I have qualified as per the advertisement of typing 35 per word, your lordship. Whereas the person who has selected your lordship, the private respondent, he is unable to type that. In between, what happened, your lordship? The authority relaxed the typing number, your lordship, from 35 to 20, which is against the advertisement, your lordship. In the mid of in the process of your lordship selection, this is the case. The respondent was given instruction to file affidavit, your lordship. They have filed. So the only question is that whether in the mid of this your lordship selection process and after the exam, your lordship, whether this can be done, your lordship. Rule of game can be changed, your lordship. This is the question.
Private
No, private respondent is one. Your lordship, the respondent. You are appearing for all, no?
There is the private response. You're appearing for the private response. Your
Respondent 7.
Number 1, 2, and 3.
One, two, three. With number 4 and 5. Zero plus the private
4, 5, and 6.
5, 4, 5, 6. With for 7.
I'm appearing, lordship, 4, 5, and
With appearing for respondent 7.
Respondent 7.
Right, has everyone appeared?
No, your
And the is been complete. Service complete.
service completed.
The officer
No. Your Lordship, order dated 27/9/2021. May I please, Your Lordship, Your Lordship. The advertisement is at page 14, Your Lordship. In column 11, Your Lordship, there is a column of relaxation. What can we relax? In the column of relaxation, Your Lordship, there is nothing that a tapping test, the per words of tapping test can be relaxed, Your Lordship. And in the advertisement, Your Lordship, any candidate who pass all the tests, then only merit list can be, Your Lordship, from Your Lordship. If any test a person can fail, he cannot be selected for the merit test, Your Lordship. Here in this case, Your Lordship, admitted position is that the private respondent failed in TAPES test as per the advertisement, Your Lordship. And as per the respondent, Your Lordship, only 13 candidates passed.
On what basis he failed?
Your Lordship, I am saying on the basis of the affidavit filed by the respondent, Your Lordship. Your Lordship, I am saying in comparison to advertisement, Your Lordship. Page, Your Lordship, the affidavit filed by the respondent, your recent affidavit file, Your Lordship. Additional affidavit, Your Lordship.
Affidavit was filed how?
No, additional affidavit, additional affidavit, Your Lordship.
19/5/2025.
Your Lordship, Your Lordship, para 5. That the may I read, Your Lordship? That the defendant begs to state that it is humbly submitted that the consequent to the advertisement, the petitioner attended the Assam Rifle Recruitment Rally with effect from 21 March 2017 at Difu for the post of clerk against the vacancy of Uttarakhand. The petitioner successfully cleared PST, PET written qualified in a written test and was thus called for a skill test by this director letter dated 21 June 17. The skill test for various state categories were conducted at three nominated centers, Difu, Jorhat, and Lit Core, by the respondents as per the availability of the infrastructure effect from 19 January 2017 to 21st January 2017. Accordingly, a skill test for the categories of the personal assistants and clerks were conducted at Difu. As per advertisement, total 100 vacancies were advertised for Havaldar, Clerk, Assam Rifle, Tech, and Trade Recruitment Rally 2017. As per result of the trade test, only 13 candidates have fulfilled the prescribed criteria of 35 words per minute. Majority of the candidates could not achieve prescribed standard of typing test, keeping in mind in maximum subscription of available vacancy in the clerkate. The competent authority decided to dispense the typing test criteria to 20 words per minute from the required 35 per minute as per Recruitment rules. This is your lordship. And accordingly, competent authority recommended that all the applicants who could type 20 words per minute or above be considered to be appeared in the detailed medical examination. Hearing your lordship, I being the petitioner, I have typed 35 words, your lordship, but the private respondent failed in doing so. As well, your lordship respondents, the authority, only 13 candidates passed that. So they relaxed this criteria in the mid of the advertisement without your lordship informing anybody, your lordship. So ultimately he tells the your lordship the games, rules of the games, your lordship. And whether that can be allowed. Advertisement, your lordship. At page 14, your lordship, of the repetition. Your lordship, specifically page 26, your lordship, where the requirement is criteria is given for tapping test. Page 26.
What are the codes?
Your-
What
Color cure, Havaldar color cure.
where is the
Havaldar color cure. What? Your lordship, page 26, your lordship. Group 3 post. Serial number 1. Serial number 1. Color, Havaldar.
Yeah.
So your lordship, as per this advertisement, all the candidates have to pass all your lordship given criteria. Then only he can appear for written examination and medical, your lordship. If anybody can fail in any of the your lordship criteria, he cannot advance to the next, your lordship.
Where is the procedure?
Your lordship, it is page 16. Last to next to para 19, your lordship. Merit list, call for training. Got it, your lordship?
So first still be a written test.
No. Candidate who qualify in all physical test, your lordship.
First physical test.
Uh,
Then written test.
Written examination,
Then trade.
test test, your lordship. Then medical, your lordship.
So what is your score in the physical and written test?
Your lordship, in fact, there is nothing like a score. It is pass and fail.
That's right.
I passed, your lordship. And why I am not selected? Only because I got 55 in the written test. And the person who selected, he got 57 in the written test, your lordship. So my candidature was rejected because I am law in merit in written test, your lordship. But all other criteria, your lordship, I have fulfilled, including this physical efficiency test, trade test, your lordship, medicals. Only in the written examination, this is your lordship. As per this advertisement, your lordship, in any candidate failed, he cannot advance to the next stage, your lordship.
Their requirement is that you make it are very certain candidates.
13 candidates.
therefore, that lower down.
Whether,
everything.
whether it can be done, your lordship, in the mid of the selection process, your lordship. After the examination is set for your lordship. Your lordship. In pay this,
That part cannot be done.
Yes, cannot be done, your lordship. Your lordship. Your lordship, the divisional bench of our own high court, your lordship, and your lordship is one of the your lordships. Here, your lordship, in para 5. Here, your lordship, the question was that whether a candidate can be appointed, because the advertisements say that from the same district a person can be appointed. In this case, your lordship, in respect of project assistant, from the same district, your lordship. Candidates should be from the same district, but it was from the different district. In mid of the your process, your lordship, it was changed. So, your lordship, page para 5. Page 5, para 5, your lordship. May I read, your lordship? Having heard the learned counsel for the party as well as a perusal of the record, we are of the view that law is very clear that whenever appointment is thought to be made by issuing necessary advertisement, normally the selection process should adhere to the terms and conditions mentioned in the advertisement, unless there is any specific provision in the advertisement which empower the selection committee to deviate from the terms and conditions. Thus, ordinarily, the terms and conditions should be strictly adhered to. Otherwise, it may amount to changing the goalpost after recruitment process has been initiated, violating the equal opportunity as mandated under Article 14 of the Constitution. Here, the same thing happened here also.
Here, first you have to, what is your cutoff in the written test? 35%.
35%, your Honor. In written, 35%. I have scored 55, your Honor. This can be reflected in the additional affidavit filed by the respondent in your office, page 116.
Yes.
That has been done according to the, this is the record pilot. Decision has been taken to lower down that cutoff.
Doubt that
Yes,
it
sir.
is taken, but
Yes. Yes, sir, that is in kindly come to my lord, my additional affidavit, page number 117, my lord. Yes, my lord.
Yes.
Lord, in 8 power to relax, my lord. Where the central government is of the opinion that that is necessary to expand it to it, it may be ordered for reason to be recorded in that it relax the provision of these rules with respect to.
What is
This
this
is-
that you're reading?
That is my lord recruitment rule.
Recruitment route.
Yes, my lord.
So recruitment route you relax it to stopping you.
Yes,
But
my lord.
after the advertisement, why have you relaxed?
My lord.
You relax it before advertisement.
No, my lord, because only 13 candidates, my lord, got the yes,
But
my lord.
maybe then you go for a fresh
And that has been adopted not only for state of, that is for the whole recruitment process, my lord.
you take a decision before advertisement. In the advertisement, you are given a
Yes,
benchmark.
yes.
During the middle of the selection process, you lower down by referring to. How is it possible?
No. Because they have the power, my lord, that is that
And this power is not the central government.
Yes, my lord.
So what file are you trying to show us? Records of which part?
My lord, that is power to relate for conduct of the trade test bill, my lord. In last portion, my lord, staff comments, my lord. As per para 8, power to relax recruitment rule for the above state post, where the central government is of the opinion that it is necessary for
We have did that. Now
Yes.
who has taken a decision to
That
relax?
decision is taken by my lord, there in earlier page, my lord. Earlier page, my lord.
Earlier page.
Yes, there is a handwritten note there.
Who has taken it? Deputy Commandant.
No, my lord, not deputy commandant, but
Yes.
authorized. May I?
Who has taken?
I'm in point number 7, the DCR is the competent authority. Director General of Assam.
What is? Who has given the competent or what is the power is reserved to the central government as per your own?
That as per that manner, under recruitment rules, my lord, in exercise power conferred to the provision to Article 309 Constitution of the India, thereby make the following rules to amend Assam Rifles Group C recruitment rule, my lord.
So you
As per office note, my lord.
you may have all powers. You show us that in the middle of the selection you have the power.
Yes, ma'am.
You have the power.
Yes, that is as per my lord, recruitment rule, my lord.
No, recruitment rule says you have the power to relax.
Yes, my lord.
Does it mean that you have the power to relax with the advertisement during after the advertisement during selection?
That is for my lord during the that is as per recruitment rules, my lord. That is not before because they have the power to relax on age, my lord, and this that
You
is
have power to do everything.
yes, my lord.
So it is the why to allow the advertisement to be published
Yes.
with your criteria and then go forward, proceed with the selection. In the middle of the selection, you decide to select. How can how can you do that? Then why have you tallied out the respondent 7th appointment?
Because your lordship, I challenge the this Uttarakhand this your lordship report.
He is from Uttarakhand.
Your lordship.
Only 2 candidates from Uttarakhand.
Your lordship, I am one of the candidates. Selected candidate is warrior. Only one post is for the Uttarakhand.
Yes.
But that has been adopted for whole recruitment process, my lord.
No, I understand you have power.
Yes, sir.
Forget. Let us not commit who has power, who has been given the power to elect.
Yes.
Your rule says central government. Whether your director general has been delegated the power or not, another issue. But
yes.
when it is in the middle of the selection, you have power. Is this the only judgment you have Rely
Your
on.
Lordship, another judgment is also there, Your Lordship. Your Lordship. Yes. In conclusion, Your Lordship, page, para 42, Your Lordship, page 21. Full bench, constitutional bench, Your Lordship. Reference.
Yes, madam.
Reason is that as per my lord,
So
this
your,
rule has my lord.
your submission has to be in terms of the law laid down by the country.
Yes, my lord.
So merely because you have all good intentions doesn't mean that you are entitled to do that. By way of an advertisement.
Yes, that is by way of advertisement because we have decided that we have
If you
taken a
wanted to go and your candidates yourself by corporate.
no, my lord,
It's on your own.
that is not our intention to choose, my lord. That is because of that only 13 candidates, my lord, got selected in
So
the
your intentions are well appreciated. But once the election process starts, are you at liberty to alter the parameter?
my lord, as per my submission is on that regard, my lord, as per the recruitment rule, my lord, we have the power to
You
elect
please
them.
go through the judgment.
Yes, my lord.
Please go through the judgment and address the court.
Yes, ma'am.
Your submission is contrary to law. We should not only dismiss, we should not only allow the petition, we should impose a heavy cost to the respondent for not following procedure prescribed in law.
Okay.
Thursday,
Next Thursday, my lord. It will be
sorry, 17,
7. Yes, ma'am.
7. Please take it.
Yes, sir.
Lordship, in this matter, senior government advocate, he will appear, Lordship. Kindly pass over for the time being.
Time being.
Please, Lord.
This is a case for pension benefit of the panchayat and rural development. So, Lordship, I like to draw your Lordship attention regarding the order dated 4/4/24. So thereafter, Lordship, these particulars are not yet submitted by the principal. So we have submitted the affidavit stating all the particulars of this. So thereafter, 5/9/25, Lordship, again, I like to draw your attention. 5/9/25, there is an order, specific order.
5/9.
5/9.
Last order is 27/5.
No, Lordship, 5/9/25, next order. After 4, I like to draw that attention because there is a specific direction. 5/9/25. Sorry, 5/2/25. 5/2/25.
Yes, Robert.
Okay, we have held the affidavit. I think that evidence will be required in the case because was it the
Have you gone through the orders? Have you gone through the orders?
last order I have also.
Not last order. Go through the orders. Follow up after a while. Can you go to the orders? You get into the habit of going through the orders.
Yes, sir.
Go through the orders.
Yes.
Mr. Roman, that's a while. Follow up.
Case of disciplinary proceeding, my lord, where a compulsory retirement was ordered for absence of 1166 days, my lord. We had, my lord, primarily alleged, my lord, there were procedural irregularities. However, my lord, the affidavit of the government, my lord, which has been filed, it reveals, my lord, that more or less, my lord, substantive compliance was done, my lord. To be fair, my lord, that is what I can see. And the punishment also, my lord, I don't know. It's maybe it's not that disproportional also.
What is the punishment?
Punishment is no, it's not discharge. Initially, he was recommended for discharge, but then it was converted to, my lord, compulsory retirement.
With pension.
It entitles to him to some amount of pension.
So, have you filed the appeal? Departmental appeals and all have filed?
But that part is over. That part is over, man.
That was modified to compulsory retirement. Otherwise, there is
Keep it hearing.
Hello.
So,
Hello.
17th.
17th, no, my lord. Can it be on 19th, my lord? Okay.
Please, Lordship. Lordship, my senior counsel is unable to appear in this matter as he is facing certain personal medical difficulties.
Who is the senior counsel?
Lordship, Arsidas.
Not a senior counsel. It is submitted by some. This is
ZH Bora. ZH Bora on behalf of Mr.
ZH Bora.
On behalf of Mr. SS.
May it please your lordship. Lordship matter relates to compassionate appointment, my lord. And my lord, on 3/4/25, my lord, the coordinate bench of this honorable court, my lord, I have given the judgment, my lord. In the light of that judgment, my lord, the petition can be disposed of.
Where is the judge?
I have provided it.
Yes.
There are 9 and 10.
The question is for also vacancy at SLC stage.
I'm just
Otherwise,
praying
DLC
for
has recovered.
reconsideration of
You
the
want
matter.
to please then tell us. Go to the judge. After a while, after some time. Mr. Borua, please go to-
No, sir, sir. Yes, sir.
we call up after some.
That's my okay, sir. Relating to the
Reading the bit.
organization of big service of the petitioner who was discharged by the authority in the 2007. Actually, in 2001, he was appointed on wage basis. Therefore, he has appeared for the interview in the 2002 and selected as the assistant for the ICTS project and posted as Mazuli Maida. From 2005, he was transferred from Mazuli to Borbura, Tribhuvar district.
You're challenging what the
ICTS project.
what is the challenge in the petition?
My lord,
What are you telling?
we challenge that is the we want that we are discharged in the year 2007 and on the petition filed by the petitioner, we are again registered in 2014. But that tax service was not conducted from 2007 to 2014. So once the condonation of this
Where is the order of the court?
Court order. Order is my lord. That is case 52. Case 52 is the judgment passed by this lordship. The OT Rita the last my lord. Last page 57. For the reasons stated in the foregoing, this petition succeeds. The office order dated 25/1/2007 issued by the respondent number 2 as well as the letter dated for 25/1/2007 issued by the Joint Secretary Social Welfare Assam and Annexure 7 and Annexure 6 respectively are hereby caused. The respondents are directed to cancel the appointment of the private respondent and issue an appointment order in favor of the petitioner for the post of LDA cum typist of the Borburu ICTS project, Dibrugarh, and Dibrugarh within a period of 2 months from the date of receipt of the certified copy of the judgment. Nevertheless, it shall be open to the respondent authority to accommodate the private respondent at other available vacancy to avoid any hardship caused to her. The copy of this order be furnished to the learner standing up to her party. So accordingly, he was appointed in the year 2007. That is the appointment order. The page 61, my lord, page 61, annexure 11. It is the Sajid Ansari. He has joined in 23/7/2014, and Finance Department has issued the pay certificate. But from 2007 to 2014, that service was not continued because in 2007 he was removed without any direction from the Nomura Sethi has filed a case because Nomura Sethi he stood second in the interview and Sajid Ansari present petitioner was sick. A present petitioner appointed, Nomura Sethi was not appointed. That is why he has filed a petition and allowing the petition authority was directed to appoint Nomura Sethi. But there is no direction that is Sajid Ansari to be removed from the service. Accordingly, he was removed and the Nomura Sethi was appointed and he filed his petition. It was allowed and he joined at 2014. Also from 2007 to 2014, that period was not controlled. Because of that, he lost the pension benefits and all the financial benefits for this period and the seniority in the service. So the responsible authority may be directed to control the service for that period.
There was no appeal against the order.
No appeal. The appeal was not filed at that time, but he had not filed it. was removed without any reason, my lord. The court has not directed to appoint Nomadasati by removing other answer, my lord. Other answer, he should seek as Nomadasati to second. So it is by this order, both were accommodated. Nomadasati and Fadi Raman. In that way, in 2007, both should have been accommodated instead of removing the Fadi Raman present in Panama. My last order, both were accommodated. In that way, in 2007, they could have been accommodated. It's because of the negligence of the authority concerned. He has lost his year of service.
Lordship, I'm appearing for 1, 3, and 4 respondents. We have filed our affidavit, Lordship, and at paragraph 3 of our affidavit, it is stated, Lordship, that petitioner was appointed by in the year 2014, and he joined in the year 2014 in Barbarua ICDS project Dibrugarh as LDA cum typist, and the finance department facilitated the petitioner to draw the first salary since his date of joining, but the finance department has not allowed any financial benefit for his earlier service, Lordship.
That is why you have come.
Which was cancelled by the order dated 25/1/2007, Lordship. Annexure 1 of our affidavit. His earlier appointment was cancelled.
Right, that has been held to be bad by the court earlier. Respondents to direct cancel fresh to an appointment order.
And on 7th of March 2018, Lordship, both Narbada Chetty and Sajid Ansari were newly
You were
appointed.
working in a post, some person was selected in order to accommodate, you were terminated. Then you came to court says your termination is bad.
Yes, when I was coming, that I came to court.
Right.
And it was allowed in 2014, that case.
If you read para number 5, page 57, para 5.
Yeah. Okay. That's when para 5. I have already read out it. Order agent stated up for when this petition practice. The office order dated 25/1/2007. By this order, he was removed, Mike. By this order, petitioner was removed. Removed. Issued by the respondent number 2, as well as the data dated 25/1/2007, issued by the Joint Secretary, Social Welfare, Assam at Annexure and Annexure 6, respectively, are hereby caused. So both the order removing me was caused by the your lordship, and thereafter directing the order to appoint me. Accordingly, I was appointed. In 2014, I was appointed. I joined and now I'm working. So the 2007 to 2014 period, I was illegally removed from the service. There is no direction from the court to remove me, my lord. They have illegally removed me. Because by this order, your lordship will see the last portion. Last portion, my lord.
Read para number 5.
Yes, para number 5, last portion.
That you are the court came to a finding that it was not proper interfered with your removal, but there was no direction to be reinstated. The direction was to issue an appointment order.
The appointment order given to the President, sorry, Namata Sati, it was cancelled, and I was appointed in her place. But option was given here, my lord, last paragraph, page 58. The last paragraph, it was given that nevertheless, it shall be open to the respondent authority to accommodate the private respondent, that is Namata Sati, to any other available vacancy. So she was also appointed accordingly. In 2007 also, the authority could have passed the order that because instead of removing me, the number of sets could have been appointed in the under vacancy which is available, my lord.
No, para 5, direction is not to reinstate. Direction is to issue an appointment order in favor of the petitioner.
Yes.
So they have appointed, they have issued an appointment order.
Oh, no.
Your claim for area salary, etc.
2014, by virtue of this order, your lordship order, I was appointed.
Correct.
I was appointed. But I was removed in 2007.
But there is no finding that you should be reinstated.
Well, if perhaps that matter not agitated before put by
We don't
the
know, but we
lawyer
go by
who
the
has
order.
conducted the case.
Unless there is an order saying that you have to be
But
reinstated.
when I am illegally removed, when I am illegally, I should get the benefit.
It's an order of the
So
court.
actually, yes, your
Not
doctor
open
can
to
dispose the petition.
interpretation.
Dispose the petition by issuing direction to the respondent authority
Yes.
to consider the representation to be filed by petitioner for consideration of its contribution of service. Then we will file representation before the
No, there is no direction. You read para 5, page number 57.
Now we are paying in our that our case is not only basis of free judgment.
Now
Because as I was not given the benefit of condonation of service, so I filed this petition, my lord.
So
That
now
is
it
a
can't
pair in my petition, my lord.
It cannot
It is not that we have filed this, made this pair on the basis of the judgment.
We do not know what
It is
was the
not.
prayer in the petition earlier. Should have made the prayer.
Had there been in this order, I could have been given it was not given. Authority has not given that.
therefore
That is why I have come before your lordship.
it was not given. Now, what does interpret
Uh,
this order?
For the end of justice, because the petitioner has lost his seven years of service, including all the financial benefits. His seniority is lost, his financial benefit was lost, his pensionary
Everything
benefit
I
is
agree,
minimum.
but the direction of the court is not
So the will
reinstate.
file, your lordship can direct the authority to
We
consider
cannot
a petition.
We cannot direct because authorities have implemented the order. If you want, you can file a review against it.
That was the relief. We have paid it so that our break service may be condoned. That was the relief.
Relief, but
So
not
unless
granted.
your lordship passed order for condonation of the petitioner directly, that the at least authority may be directed to consider the representation to be filed by
Be cannot be because you are appointed person to this order. This order is very categorical.
But I am in 2007 I am illegally removed.
Everything is
I am illegally
right.
removed by the respondent authority.
Then you should
Because
have,
of that I
then
should
you
get
should have
relief.
gone in a beat or filed a review against this order instead of coming separate writ petition.
And then because of the illegal act of the respondent, we will not get any relief.
Your writ petition, when was it filed? In 2007.
Yes.
You filed a writ petition in 2007, disposed of in 2013. You did not go in appeal, you did not file a review, you come in 21.
At that
Thinking
time it was not filed.
that
It was not filed, but the
how can we interpret this order? This order is very categorical.
order is passed in 2014 party without giving any mentioning of the gap
Then you
period,
are,
my lord.
then you are aggrieved by this order.
It is the respondent authority who has removed it. So at the time of giving his test appointment on the strength of his judgment, they should have considered that period, my lord.
Yes.
Right.
For respondents 1, 3, and 4, Lord.
Lordship, in this matter, we have been asked to obtain some time, Lordship, because they are yet to provide us the necessary instruction, Lord. They require some time.
How much time?
Lordship, at least 2 weeks time is required.
Yes.
Because they could not trace it to the record, Lord.
You cannot
Trace the record, Lord.
trace the try the prayer from time and week further time.
2 weeks, Lord.
Vacation
Yes, Lord. After vacation.
Week.
Deeply applied.
after vacation. After vacation. Fine. That's why give the 21st.
25.
Made legal lordship. Lordship, in this matter, government advocate was directed to obtain instruction as per in terms of paragraph number 4 of the order dated 4/4/2025.
Yes,
Yes,
there
Lordship,
are any
that's
instructions?
actually stated, Lordship, but basically the thing was that we were required to obtain that as to whether the case of the petition was placed before the state government, and yes, so,
And what was the outcome?
so
What was the
that,
instruction?
that is awaited, Lordship, for what is happening for the FLC.
Was it placed or not?
Because Lordship, because after that this thing, Lordship, it is the department who used to place, Lordship.
You again read this order, para 4. Have you read para 4? Para,
Yes, Lordship, I have read this order of 4/4/2025.
yes.
So I have read. I don't like tell offense as to whether the case was placed before the state government, and if so, what is the outcome? Lordship, Lordship, that part actually PW has to answer, Lordship, because once the DLC this
Who is for PW?
the holder itself,
Yes.
Today I am
PW, for that.
I asked hard work. Because matter
At 2 p.m. 2 p.m.
Obliged.
Okay, deal.
This pertains to discharge from service, my lord. You can have it on a hearing day, my lord. Pleadings are complete otherwise.
Service.
Pleadings are complete otherwise.
Meetings are matters. That way you discharge.
My lord, in
21.
21.
21. 15/3/20. Oh, no. 27/7/21.
Second, right?
My lord,
With
keep clear.
I
45, my lord, is also discharged. Pleadings are complete.
Sorry.
Keep clear.
Wait, please, your lord. In this
Lordship,
matter,
the learned counsel is on left, and this matter be taken up.
just a moment. What has happened in this matter? The petitioner his services were terminated without even serving a notice. No opportunity of being heard. Just one line that your service is terminated. We're challenging that. Initially, your lordship, they have filed the affidavit. Then, your lordship, what has happened on the last occasion? They came up saying that no, we have issued a notice. But that was not brought on record because that was the only allegation we made in the main writ petition. So that should have been in the affidavit. Then they took time, your lordship, twice, saying that we'll bring that on back. Till today, they are not taking it. And now, what is on the last, your lordship, there was a direction to file an affidavit. They have not filed it. Today, what will happen after the time being?
Whose behalf are you making?
The Upamanya.
Where is he?
He is on lake.
Please call him.
Can this
Call
matter,
him.
can this matter be taken up after some time?
Yes, please inform me. Call up after when. Inform. Or at 2 p.m. for the page. 2 p.m.
Obliged.
Last occasion, lot of some instruction of the whether payments are made or not. So we have filed the affidavit stating everything. But we filed the additional affidavit stating all the in annexure A to law. Got information.
Yes, perfect.
My lord, this, I have gone through this, my lord, additional affidavit, my lord. They have calculated on the basis of increment, my lord. But the issue here is whether he is entitled to increment, man.
All laid down by the Supreme Court and also I am entitled for this increment because
And
wage means including increment of.
and my lord, and main issue here is, my lord, increment was not granted during the dice non period, my lord. They have not challenged it in the written.
Keep it for hearing.
My lord,
After
my lord.
Monday.
not Monday, like or August.
Because it's a retirement of long pending
9th of July.
29th of July.
July.
We need 1 week time to file our reply.
Had to be decided after 4 weeks, enabling the respondent to file reply. A handling court.
Revenue department.
But
4, 5, and 6.
Can it be taken up after some time, my lord? Item number 52. My seniorism late in another court, madam. Madam, the fixed for hearing for next week. Madam, the fixed for hearing in the next week. We have filed affidavit.
File affidavit.
Yes. Only one instruction is necessary from the revenue department, my lord. In the inquiry report, 2 large model was to be further examined. And whether they were examined or not, that is still required. Revenue court. Revenue court. Dr. Palisi, page 47, the inquiry report, last part, serial number 6. When proper inquiry against the forest for Burwa, SK, Lambudo Hazuka, D10, Lat Control, Sunil Gugu, data entry operator under revenue cycle is necessary to unearth the actual facts about the incident of starting the false data entry on 9/12/2017. That is done by the Joint Secretary Revenue Department. This is whether they have done it or not.
Page number?
Page number 47. This is the inquiry report, last part.
You're reading from serial number?
Serial number 6, last part. After inquiry, statement has been recorded of the cases and last a proper inquiry against the Forest Base Bureau, SK, and Lambudo Hazuka, D10 Mondol, and Sri Sur Gugu, that anti-operator under revenue is necessary to unearth the actual facts about the incident of inserting false data entry to and fro. That is the revenue department, they can obtain it. My friend, Handik is there, Malot. He can obtain it. And it's a 648 Malot. Because he has admitted when he was a circle officer at Tisupia, they wrongly, not wrongly, but intentionally enter another name in against another partner number. After complaint made by the complainant, these facts are put on.
What's the status of the inquiry?
Hello?
What's the status of the inquiry?
Inquiry, this is the inquiry report submitted by the inquiry officer. Further, they have, the inquiry officer stated that three more persons are to be followed examined further to unearth the actual fact.
And what is the stage of the?
That is the I want to know. That I want to know whether they have done or not.
So that why where is the order for review?
No, Lordship, मैं पहले सीधा annexure 13 page 63. That was challenged by the
63.
63, Lord.
Okay, this is
the suspension order.
Suspension order.
So she's now on the suspension.
Under
Still
suspension.
under suspension.
Then where is no review called for?
That was I don't know regarding.
My instruction, my instruction, my lord, review has not been conducted yet.
I will obtain instruction regarding review, my lord, and status of departmental. Please, after 2 years, my lord, I will obtain.
Let it come up on 19th, my lord. Otherwise, the proceedings are complete in the case, my lord.
Right, 19th, not 19th. All right. Right. Update is status of
Departmental and review.
whether it is due. 19th.
Obliged.
For activities file, Lordship, we have brought on record our updated instruction also. For an additional affidavit. Petitioner has already been considered Lordship and he is placed in serial number 4, Lordship. From the promoted from ACS to IAS, Lord.
Where is the
Lordship, fix another date, Lordship, on the next date.
Apologies, your lordship. Lordship, my senior is engaged before another court.
get the minimal instructions? What is to be done? Read the brief and find out
Will do, Lord.
what is this. If the young lawyers, you are not please, but then what is the matter about? Why is it to the court? When is the election likely to take place?
There is no such instruction on that particular because the query of the petitioner whether he has been considered or not, Lordship. So this is there. So he has already been considered and he is there in the serial number 4, Lord.
PM. PM.
Lordship may fix it another date next Tuesday, Lordship.
However, we are in item number 52, your lordship, which I saw on the display board. That is why I asked. But it appears to be 53, your lordship.
You are appearing in which matter now?
In item number 52, I saw the display board and I rushed since my senior was.
52 is already over. Somebody has appeared.
Yeah.
Then it must be a mistake, your lordship, on my part, because the display board was mentioning 52.
Some council had appeared in 52.
I mistakenly appeared.
Are you are not appearing in 53?
No, your lordship.
And Lordship may
Apologies.
fix it on another date, Lord.
At the afternoon.
53 is Bhupesh Chandra Raj.
Not.
Lordship, in 53 is Bhupesh Chandra Raj.
You don't have a cause list.
I do, your lordship. There was some mistake in the cause. Apologize, your lordship. We appear in this matter in Bhupesh Chandra.
But I have received the record, Lordship has directed to produce the record.
Status of the appeal.
Status of the appeal, the appeal is not yet disposed of. It is under consideration.
Is under consideration.
Lord.
Why not dispose of the appeal?
The only the status is known to me, my lord. I have been informed that the appeal is as much consideration, but at what stage or how much time they will take for that?
Will they issue a direction to dispose of the appeal?
My lord, it will prejudice.
Right?
My lord, it is a case of 2019, my lord. Already 7 years, 8 years has passed, my lord.
You have filed an appeal.
I have filed an appeal, my lord. Only statutorily they are entitled for 3 months, my lord. They have taken 7 years, my lord. They missed the bus, my lord. Now taking up the appeal and disposes against me will prejudice me, my lord. I have already, it is violative of my fundamental right.
Disposal of the appeal means appeal doesn't say that it will go against him. Appellate authority will consider it.
If it is
may be-
go against me, I have to come again to this court, my lord. It will prejudice me, my lord. The matter is completed for adjudication, my lordship. Here and dispose of the matter, my lord.
Inquiry report is here.
Report, my lord, basically the allegation is that the petitioner was not given the opportunity to cross-examine the witness.
Not only that, my lord, it is so many points we raised, my lord.
But that is the basic thing, basic point, my lord.
Not only that basic point, my lord. Lordship may kindly hear me, my lord.
From the record, what we have to show, my lord. I could gather that the petitioner was not given the opportunity to cross-examine, but the record shows, my lord, the evidence that they
Charges itself is vague, my lord. Charges is not evident, my lord. Rule 9 has not been followed, my lord.
No, let us submit one by one. The record is there, my lord. The witnesses are examined in his presence.
Priority should be given to the petitioner, lest the petitioner be heard first,
Yes,
my lord.
yes. Otherwise, lordship has called for the record, and the purpose for calling up the record is that whether he has been given the opportunity to cross-examine or not. Enquiry report says that he was given, but he declined. The witnesses also says, my lord, that the delinquent declined.
That is a one part of the petition.
That is the
My lord, my grievances, my lord. Number one, charges is not definite, my lord.
Where are the charges?
Charges at as page 20, my lord. It is at page 20, my lord. This is not a definite charge, my lord. This is an indefinite charge.
How do you define a definite charge?
Definite charge means a date, time, period on when I was absent from the unauthorizedly in duty, my lord. That has to be mentioned, my lord. You cannot, they cannot.
What is your reply to the charge?
My written statement maybe says, I have on paragraph 4, I categorically says it is vague. Besides aforesaid functions and report of the Superintendent of Police, Pokrasa, the Additional Director General of Police has been pleased to add still more vagueness by addition of few adjectives detrimental to the career of a young budding officer without any substantiation from his side. These are all vague, my lord. I have raised this issue, my lord, before the on my WS, my lord. There is a katana of cases, my lord, from the Supreme Court on this point, my lord. The charges should be definite so that the delinquent may give a reply.
Is there any attendance register
My lord,
or mechanism to show that you are present in the district on a particular day?
My lord,
You are the SDPO.
I am the SDPO.
Now, as the SDPO,
My lord, just a minute.
You first listen to the query of the court.
My lord.
As an SDPO, the fact
yes.
that you are involved in your duty,
My lord.
are there any corresponding collateral materials available to say that you are available in duty, you are performed this duty, or you are seen at this place within the jurisdiction?
Lordship may see inquiry report, my lord. Inquiry report, findings at 34 mile, page 34 mile. After going through the statements of all contra, it is clear that the delinquency Anand Togbi, APS, SDPO, Gosaiba could be found seen by the AP Kokar during the period of riot, either telephonically or physically.
Yes.
That is enough, my lord.
Then
Lordship may kindly see page 43, my lord.
what was the order passed by the disciplinary authority of India?
Disciplinary authority passed the order at page 49, my lord. The governor of Assam is therefore last line, my lord. Please to order withholding one increment of cumulative effect with effect from the date of next increment due to Anantagvi APS, it did an SDPO.
They have accepted the inquiry report.
My lord, they accepted the inquiry report. Without any reason, my lord. They have to give citing reason for. There is a order from the judgment from this honorable court to that effect. They have to give reasons why they have agreed to the findings of the disciplinary inquiry authority. I will submit those judgments. Lordship may kindly come to page 43, my lord. 43, my lord.
We'll take it up at 2 p.m.
But if he is taking up the matter for disposal, because today record I have received and I'm placing it before your lordship. But for disposal, can you keep a date? If the matter is taking up for final disposal, kindly give a
The point is being date. Counsel are not available. Both counsel will have to be available. What is the difficulty if we proceed?
but for final disposal, I'm not. I have to go through that because for production of record.
17th, 17th June
17. Okay.
for admission hearing.
Lord.
And then it.
Lord.
Yeah, that one put order law. Secretary, I think after beginner is required to place your own certificate code that whether this 55 number of distinct petitioners comes under the purview of 517 that government is going to give the benefit. Now, thing is that that email is not available in that code. I have already. I have waived some. In our affidavit, on the last part of affidavit, one line has been mentioned. If lordship permit, I may allowed to be read lordship.
Are you making a mention of this behalf or you are arguing?
No, basically, I am appearing on behalf of my lordship that I'm not you did it. Then lordship on the next day lordship also.
Only at this stage, Lordship, one out there, the records may be called for because everything depends upon the record of the minors. And that has been not produced any a day after, because it is a pensionary case, Lordship, all the persons are retired persons. Pending before this court.
Mr. Nayak from which
UDP, Urban Development Department.
Council, Setting Council from Urban Development Department.
But
Nayak.
It is his submission on 5-2.
Produce the record.
It is he submitted before the court on 5-2.
Communicate.
Yes, additional to the office of additional legislation.
Yes. Yes.
If that order of the citizen have harmful also, but there also the case of the petitions not be rejected by the SLC, and after the same being rejected in the year 2020, the matter was being sent back to the public health department. PHC.
So, Lordship, if that's so, it is not been pending before the SLC or this judgment to this order to be covered. So, Lordship, if tomorrow PHC places the matter for the SLC, the next minister meeting,
Public Health Department.
Public Health Department,
Public health.
Engineer. Yes.
PHC, Public Health Engineering
There is
Department.
no static
All Lordship, may fix a date, Lordship, I'll inform him, Lord.
He's here, he appeared today. We have disposed of the matter that is like.
Lordship, yes, but this matter is not been pending for the SLC or neither DLC, Lordship. That is the case.
Not about pending here.
Already SLC minutes are
Right.
set aside by that order.
We have dated 18/9/24. But the it's not processed. That time the matter has.
Yes.
You inform the part it take it up Friday.
Deeply organized now.
Lord, last occasion, my lord, I appear it is better. I was asked to, my lord, obtain instruction regarding notification enacting the additional affidavit for the central government, whether applicable to the state government or not. But on query, I have been informed that there is no notification in the government of state government. So, my lord, petitioner is saying the private respondent is retired in March 2025 and she is eligible for promotion. Lordship can direct it for consideration of promotion. It is the simple case, my
As per Rule 56, my lord, last time I have shown, my lord, of the state rule, my lord, that if a person is, my lord, retired from service, my lord, he is not entitled for promotion, my lord, and his extension has been given.
He is not seeking the promotion.
That is the rule, my lord. If you also go to the additional affidavit, my lord, everything will be clear, my lord. As per direction of the Honorable Court, my lord, I filed the additional affidavit, my lord. If you also go to the additional affidavit, is my lord. ये लारी वाला उल्टा हो गया There's my lord 180. দাদা এই তাতে মানে চাকৰি কৰা যে Page 180 annexure Q. In pursuance of the government letter number.
Date of the poem.
It was page 180 annexure Q.
There is no page 180, 179 and 179 capital A.
Well, that my lord office order dated my annexure Q.
What is the date of the?
Yes, my lord.
December.
Yes, my lord. That is 25/4/2025.
25/4.
Yes, my lord. Additional affidavit dated 27/5/2020.
No, I'm not asking you additional affidavit date. I'm asking you the date of that office memorandum notification which you are reading out.
25/4/2025, my lord. 25/4/2025.
181. Office memorandum 181, 9 December 2022.
After that, my lord, my affidavit swearing affidavit, next page, my lord, annexure, first annexure of the additional affidavit.
Yes, what is the date in the first annexure?
25/4/2025.
It is not here.
Dear my lord, year, my lord.
It is not here. It's the affidavit that you have filed.
This is his extension order, man. Petitioner's extension order.
That is the order, my lord.
This is the additional affidavit filed by
Petitioner.
the petitioner Jonaki Das.
Yes, my lord. 27/5.
27/5.
2025.
At annexure 1 is office memorandum dated 9th of December.
Yes.
2002.
His extension.
Before that, my lord, there is a notification, my lord.
Before that, no notification. Before that is affidavit.
No, before that, no, no.
Who was there? Before that, 180 page, that is the order of the extension.
There is no 180 page here. 179, 179 capital A. Then 180.
This is the my notification.
But it is not here. Have a look.
Right.
You have a look at it. Second.
My lord.
We'll pull up it here.
Yes, my lord.
Find out.
Yes, my lord.
It may have been picked up somewhere.
Yes, my lord. I know. I'm a still move for
25
Yes, my lord. 25
That is separately available, not here.
Oh, yeah.
There is the file. Not as a
Or
part of
annex is part of
the document.
Yes, sir.
Whereby extension.
Yes.
Extension.
Yes, my lord. Yes, my lord. That you are prepared from his service. With this extension.
Now he is considered for promotion.
No, my lord. Earlier when I
He
was
is not even claiming promotion. Lastly, actually, repetition what a pleading case. Petitioner and respondent for there between transfer of seniority. In 2007, petitioner earlier was a senior and thereafter respondent number 4 was made senior. Till 2007 to 2008, she was sleeping. And 2003, suddenly she woke up, oh, I should be senior, he should be. Why? That is his case. That's why in repetition, he is praying for setting aside those seniority. Now, seniority and juniority has come to an end after retirement of the respondent number 4 in March 2025. He says, it is promotion. We are not saying the respondent number 4 we are not going to be promoted. Only petitioner can be considered for the promotion to the post of supervisor.
yes,
That is the. I'm not saying. And
sleeping man.
yes, yes. So where you were sleeping, 2008 to 2020. It's simple, my lord. Okay, assuming that this notification is applicable to the state government, no, he will not be promoted. There is no initiative to promote the respondent number 4. He has already been retired. Extension is given because he was a awardee. That is a provision is there.
And as per Rule 56?
No, Rule 56 does not come here.
You want promoted to be post.
I am
Superintendent.
Next post superintendent.
But you are already promoted.
No, my lord. I was promoted to the UD, my lord. Upper division assistant. Senior assistant. That is called senior assistant. Yes, my lord.
Now for promotion to the next.
Promotional post is the superintendent.
Now for superintendent, you have all the requirements.
I have all the requirements.
Including service.
Yes, my lord. I am in service. I am going to return on 1/8/2020.
Then why are you praying for notional promotion?
I am not asking for notional.
Para number.
My lord, earlier what happened, my lord, 2011, I was LD, my lord, and he was UD. In 2007, my lord, I was senior to the respondent number 4. In their speaking order, they specifically, we do not know how the respondent number 4 has come above the petitioner, my lord. And there was a, my lord, they should, my lord, serve the garrison list to the petitioner. They never served the garrison list to the petitioner. It is admitted position there, my lord. But in 2020, they said, my lord, that we have served.
All right, so we are closing it now.
We are closing only simple direction to consider her.
Yes,
If she is eligible.
yes, my lord. Yes. What?
What a claim for an
Petitioner is it UDA or senior?
Senior assistant. Now it is called senior assistant. Earlier it was called UD.
But it's serving as senior within bracket earlier or
UDA.
Which
department?
It is general administration.
Director, no. Director of Information, Public Relations.
Public relations.
Oh, yes. Right.
Sorry.
Director of Public Information and
Director.
Yes. Director of Information and Public Relations.
Because of that private is not poor. It's no here is the 31, and thereafter the petitioner became considered and required for the next higher of written for which commission takes the petition signifies that person number 4, although I think that method six and and party and her and his state of petition now after next is 31 the petitioner agrees that although the petitioner, although after petitioner here there is a hidden and required to be considered for higher written, but the extension service given for 4 may be taken to the ground for declining claims and direction take all steps for and for initiation for you are representing private response.
Yes, my lord, for respondent number 4.
What you have a
So, my lord, after retirement of the respondent number 4, his service has been extended for.
Are you claiming for promotion?
No, no.
Uh, I you get for claim for Roy take care of
Yes.
for not that that view of the matter that that it is that or take undertake of the modification of another element as per provision of the strike. Here that also refer FR
56 note 5.
Parliament group wherein at note 5 it describes that government right in shall not
That is for that, FIR does not come in this case, because not a pleaded case. On the basis of notification, my lord, he has been
Office
extended.
memorandum.
Now, he is not prejudiced at all. He is not prejudiced otherwise. His extension is only because of his
Office memorandum.
office memorandum is 14 December 2022. He is eligible for extension only 1 year. This is a policy decision of the government.
he's
Loco,
not questioning his extension.
yes,
Petitioner is not agreed by the extension.
yes.
Petitioner is agreed
Promotion.
by that after extension, person may be considered for.
Yes, yes.
He has not claimed it.
Yes, his service should not be disturbed.
He's not challenging that.
Not challenging, yes, sir.
Being heard now.
Yes. Okay.
instead of instead of paper of the five here that purpose for it, it, that part. Neither a option to the that you will equal step process the process to initiate process or superintendent.
Yes.
Your director,
Director of Public,
Public
director
relations.
of
Director of Procedural Public Relations.
public that this site the expedited within the outer limit of 90 days.
99, I will be retired.
He'll be retired.
When are you retired?
First August.
Allot 1 month.
The petition has the petitioner will superannuate on the responsible within 4 weeks from the date of 4 weeks from the
Yes, yes.
Obliged.
As of now.
My lord, extremely sorry, my lord. I missed the item number 22, my lord, due to traffic jam. My lord. When the item was called for, I missed the item. My lord, already I have that 4 weeks time has been granted. Lordship may kindly fix a date, man. Otherwise, there's some urgency is there.
4 weeks the date up.
Half an hour ago, my junior college part expired. Item number 54, my maybe 54 and any date, my next week or
What is the matter about?
my promotion matter. I was not promoted, my lord. Yes, junior
You're
was
still in service.
my lord.
Both matters the promotion.
My
Yes.
My promotion is hanging on because of the stay order of the case. My promotion is hanging for last 5 years.
Tuesday next, my lord, if possible.
We heard by the
Keep it on 19.
19. My lord. I'm deeply
Yes.
obliged.
Fine.
Deeply obliged.
Then he comes to corporate.
You are for the private.
Format. Item number 54.
Yeah.
So for next WC, I'm replacing my lord. That is WC 2297. 55, I think.
It's connected.
Connected. Man.
So both
Yeah,
will
Lord.
come up on 19.
Oh, Lord.
My lord, I have got the instruction, my lord. It was, my lord, considered in 2019. Serial number 41 is the, my lord, her name, Pinky Onibora, my lord. My lord, it was rejected. In the right hand side, in 2019 only it was rejected.
Lord, I may be given a copy of.
Yes, my lord, right away, full match.
So that I can go through it.
I was not.
We have to close the matter. Because
Yes, he has to challenge this.
you're agree, you bring it on.
Therefore, my lord, a copy of the
Yes,
same,
yes,
my lord,
No, no. We give you a copy, but we are saying that we are closing this matter.
Because nothing remains.
Because if you are agreed by this order, you have to come.
in that event, definitely, I have to challenge that order. My lord, till now, my lord, I am not know, my lord, what has been.
Nothing has happened. Your case has been considered rejected. Appellant does not possess required qualification. Application for pending for recommendation for audit.
Can it,
Date limit.
SLC man.
can he have it through an affidavit?
Why are you, why do you want it on an affidavit? The order. We are recording your statement. That the order passed.
I will keep this in on record.
He said, if serve your copy, your copy. If you are agree, if you come back, so your prayers are repeated.
Yes.
Heard. So it two read. And it died. 779. The time. Death. Immediately after of 18 years of age, I have application of the property. Yields. Of 89. Commented the case. Property. Certain. Call for. Required. Really very necessary. And it can be taken for a it one it being direct that it by it but are for it if are might take it well of 19 if by the it for a it if the and they will take on following one prayer taking it with that it further it's like voting. It affected 30 now. Uh, when
Obliged.
This morning, I have received some instruction, Lordship, on behalf of the Director of Medical Education. So I please
be an instruction.
Yes, Lordship. So, Lordship, they are seeking for 1 week further time, Lordship.
Lordship,
So, Lordship, earlier also I took time, Lordship, in this matter, but since I have this instruction, Lordship, this morning, so I'm placing it before your Lordship. So, Lordship, can this matter be taken up on 23rd, Lordship? Since they are saying that they will furnish me the instruction.
Right? It's board. Why do being so liberal? Last, second last day, the audit.
23rd, Lordship.
Your instruction is to pray for 1 week, they're giving 1.
Yes, Lordship. That's, Lordship, on Monday, Lordship, 23.
Here taking this matter again. 13.
Today, 11.
Sorry.
23rd.
Actually, I wouldn't have said it. The last time when I just pointed it, he was aggressively arguing, not even allowing me to submit in this. I'm very unhappy with the way he conducted last time. This, but I'm not objecting today. He's very liberally submitting today. I'm not. That is why I'm not objecting. But last time the way he submitted it was very unacceptable.
Well, you should apologize to a elder brother in the profession.
Yes, Lordship. So submitting a for telephonic instruction, Lord. He got angry.
When I was making a submission, he was not even allowing me to make. I'm not against anybody, but let me complete. Then you say. Today I'm letting him say. That's the reason. Anyways, your lordship on 20th, as your lordship. Well, let them on that day, your lordship, at least file the affidavit or produce the document.
Yes,
with regard to the notice which they submitted. They have.
The next day fixed, the respondent will produce for the court the relevant material, support their contention that notice was proper served on the second on 20.
Highly
Obliged.
Lordship.
The other side is not there. But the case is, my lord, here. I was given a major penalty. I was the chief manager of the Indian Bank. My only allegation against me was that while proceeding the loan, some delay and latches were there, for which the loan became default. Ultimately, that was acquired back, and a major penalty was imposed. They have filed affidavit, my lord, taking into consideration the limited scope of judicial review in a disciplinary proceeding. Appeal was there. Appeal was upheld the reduction in post That is the major penalty under the Indian Bank Service Disciplinary Rules. My lord, two grounds, one there. One is it is shockingly disproportionate. It cannot be a case of major penalty. And the other, I rely on a judgment where it says the loan was not a direct signatory of me. Me along with other persons were in. When this allegation was before
the punishment?
my lord,
So the punishment,
my lord, the punishment imposed is reduction in grade, my lord. Reduction of grade, the
that's
length,
major penalty.
major. My lord, the language used is, my lord, reduction of grade scale as per regulation 4G of Indian Bank Employee Discipline Appeal Regulation. The major penalty.
What is your
My lord, my
what is the ground for?
two grounds. One is it is disproportionate because it is a major penalty. And the second ground, this loan, I have taken this ground before the appellate authority that this involved other lot of persons in line for sanctioning a loan. Even a lot of
You
persons.
are the highest senior.
But those persons, nothing was taken against them. They have given every record for which
But ultimately, only the section that your
my signature. Yeah. But during, my lord, your lordship will find in one judgment, my lord, I find from the Supreme Court where it has said when the language you use is, my lord, your lordship found this is in, my lord, 2008 12 SCC 331. My lord, if your lordship may look into it. Paragraph is 20 and 22.
and 20.
2020. 2020. My lord, para 20. May I read it slowly? We may reiterate the settled position of law for the benefit of the administrative authorities that any act of repository of power, whether legislative or administrative or quasi-judicial, is open to challenge if it is so arbitrary or unreasonable that no fair-minded authority could have ever made it. The concept of equality as enshrined in Article 14 of the Constitution embraces the entire realm of state action. It would extend to an individual as well as not only when he is discriminated against the matter of
So you
excess of
give with regard to
my lord, this
bank
is with regard to, my lord, this is judicial review grounds of, my lord, and this is the departmental inquiry, penalty and punishment. This regard, my lord, para 22 your lordship will find.
but there is later judgments with more elaborate
My lord,
grounds based on parameters of
parameters. My lord, here, my lord, because there are what I find from the chart, all were not proved. My lord, here, if I take your lordship to the chart, that is that page.
But where is the other respondent?
My lord, he sometimes he comes, he doesn't come, my lord. Here there are nearly about 6 charges taking into consideration A, B, C, D, and others. More than 20, because more than 20, all are not proved. Some are proved, some are partially proved. It starts at page 287 and at 10. Your lordship will find.
Where is the order of the disciplinary?
Well, the order is at page. This is the order. Ultimately, it culminates into page findings, and ultimately it comes at 387. Taking into account the gravity of charges, imputation held as proved, loss involved, and factors of the case, I impose such and such. 387. But this loss is not a loss because they have all recovered through the DRTA. They have sold the properties by bank. They have sold the properties. They have recovered the properties, and at present there is no loss. All the properties have been recovered back.
These matters in case of bank employees, the yardstick
Slightly
stringent.
Stringent.
Because we are dealing with money and there's a public involvement, public money.
But here, I have not dealt with any money. My only thing is that when the papers were before me, some letters were there, as it has been said, but I have placed my submission in the before the appellate authority, that is in their affidavit, my lord. They have filed an affidavit, and the running page is at page 44, 444, 444 in the affidavit filed by the bank. Appellant submission in his appeal. The Lordship has got it. My lord, with due respect and reference to subject cited above, I request kindly review and reconsider the house punishment imposed on me. None else was tried in the case except me. I respectfully submit the details below for perusal of favorable consideration. Sir, I was called for explanation for the omission commission in sanction of 11 home loan accounts during my tenure in the Russell Street branch, Calcutta. I was suspended and charge sheet was issued on such and such. This itself is a great punishment for whereas others who processed these loan applications were allowed to work. The inquiry was ordered by the respective GDM and DA on the 9/1/2020 and preliminary inquiry held on such and such. PO submitted MEX in the month of October. In the month of retirement of my defense assistant, I could find a defense assistant later on. And final sitting of the regular inquiry was conducted on such. Now, these are things are there. Here the submissions are below. I would like to submit the following synopsis, such and such. Mortgage loan account of Hridoynath Roy. There was no disciplinary proceeding pending at the time of sanction of mortgage loan. It need not be mentioned that there was tremendous pressure from higher up to extend quality and secured loan. So a known customer is better than a new entrant. Hence the loan was sanctioned without any other consideration. The loan was processed by Sri Kunal Misro, Chief Manager Corporate Office, Chennai, who was specifically deputed.
We do know the parameter. It's not an appellate authority.
My, your lordship is not.
The only question is whether natural justice,
My lord,
or the follow, or the
all the technicalities are there.
But
Going
punishment also maybe in some extent whether proportionate disproportionate. But otherwise, whatever view they have expressed, it appears primarily be a very exhaustive.
They have given it. My only thing, my lord, that if I can, that last time also, my lord, I talked to the counsel for the other side. He says that, my lord, because those other persons who were involved in the loan, nothing was taken, and it was placed before the appellate authority. The appellate authority has not discussed anything about those persons. So if it can be remanded back to the appellate authority to see it afresh, along with the cases of the other persons, nothing was done against them because the loan was not only thing. Chief managers, everybody was involved in it. All of the officers were involved. He is not the only authority because chief managers and others, they have signed those loan applications. Because, my lord, everything is pension and others now, because he has retired. 17, I have fixed many other cases. My lord, can it be on, my lord, July 15th?
Yes,
15 July. 15 July. My lord, once I talked with him, my lord, about that appellate authority remand back that I talked with him, my lord.